relating to the relationship between the Union of the States with a priori notion that these have to be understood to conform to some theoretical concept of federalism. And I make bold to say, the framers of our constitution have created a system in which the union can refuse a bill passed by an assembly from becoming law. So, this what is uncharitably characterized as a veto, and I'll say why I call it uncharitably characterized. That exists anywhere in the Constitution, unless we rewrite Article 201.
But according to you, the union can reject a bill passed by both by the houses of the state legislature.
Yes, ma'am. Should it is a matter of high discretion. We always say in rare circumstances.
We are not going into question of should it or should it not.
Exactly.
But according to you, the union has the power to do so.
Yes, madam. And that is plain from the language of the proviso to 201. So this entire exercise of trying to avoid a veto-like power overlooks that the language of 201 does not admit of any such limitation. Now, if that is the starting point of the debate, and we give up the notion that finding a veto is antithetical or erodes a federalism as envisaged by the Constitution, then we come to very different conclusions. There are two articles which have not been addressed are the width of 361 and judicial review. And ultimately, Malad, we all come to they will all lead to the same conclusion. Whether you look at it from the justiciability point of view or you look at it from the functional and the operating point of view of how these articles operate, the conclusion will be the same. And that's what I propose to Malad, put across your Lordship's kind of consideration. If vetoes are not an anathema to the constitutional scheme, then let us start without any preconceived notions, seeing what the language of Article 200 leads to.
So according to you, the governor has a veto power under Article 200 to withhold.
Using words like veto perhaps are an uncharitable characterization. The governor has the power to withhold assent.
When he argued that you only argued that if vetoes are not anathema to the Constitution.
Malad, I said what is uncharitably characterized as a veto. Malad, I said what is uncharitably characterized as a veto. But it's a convenient shorthand expression. Malad, I call it that's why in my note also I've said it's uncharitably characterized as a veto. But veto has certain pejorative consequences which we don't use for high functionaries. A veto is something you use for personal interest. Nobody here acts in personal interest. Now, to get to where I have, well, there are 2 or 3 basic points which we need to keep in mind. And this is our federalism. What defines our federalism? Let's be clear. The Constitution, if your Lordship has para 1.2, I made this point. We have a marked difference in the scheme in relation to the legislative provisions relating to the union and the role of the president vis-a-vis the union government, as against the legislative provisions relating to the states. So we start from there.
Just for sake of clarification,
Yes.
your argument was that the union has a right to reject a bill passed by the legislature.
Yes.
So whether that power can also be exercised by the union in respect of list 2?
Yes. I'll make it good. I'll make it good.
Even if there is no repugnancy with the central law?
Absolutely, Manoj. Under Article 201, there is no such limitation. Manoj, we have always started this with certain preconceived notions. There is a separate 254.2 is a different matter.
What happens to the Constitution reserving subjects in list 1 only for the union, subjects in list 2 only for the state legislature, and in the list 3 for concurrent list?
But that is 254.2, Malot, not 201 proviso.
So
there are separate powers.
While reading 200, we have to ignore 254.
No, Malot, they are independent powers operating in independent circumstances. Some of them have conditions precedent, some of them do not. If we start, Malot, stitching up these provisions, we are eroding what the framers of
the principle which know is of harmonious construction.
Malot, there is no disharmony. There is absolutely no disharmony. If we start with a premise that any such stymieing of a bill made by the state is antithetical to the Constitution, if we start with that premise, then the disharmony starts. If we read the Constitution to understand what was the structure the founding fathers had in mind, then the disharmony disappears. So that's why I start by saying we don't start with any preconceived notion. Let's try and find out what the Constitution says. And that's why, my Lord, I don't propose to cite any judgment. I invite your lordships to read the article view.
Yes.
The first is, my Lord, let me cut to the chase. If your lordship pick up 201, and my Lord, your lordships have been told this repeatedly, and long reasons have been given. I need to only state it. Each word of these provisions was carefully calibrated. Look at 201. Where a bill is reserved by a governor for the consideration of the president, the president shall declare that he assents to the bill or that he withholds assent thereof. And provided where the bill is not a money bill, the president may direct the governor to return the bill to the house, or as the case may be, houses of the legislature of the state, and with such message as may be mentioned. And when the bill is returned, the house or houses shall reconsider within a period of 6 months. And again, if it is passed by the house with or without amendment, please mark the words, it shall be presented again to the president for his consideration. Now, my lord, and your lordship has seen the language of the first proviso to 200. I don't need to go to it right now. I will at some point deal with the language. The words shall not withhold assent therefrom are conspicuous by their absence and cannot be read in. We would be rewriting this proviso. This defines Indian federalism. And my lord, there's nothing shocking about this. High constitutional functionaries in a democracy are in the ultimate analysis.
Dr.
My lord, a
Ambedkar,
democracy functions by the good sense of the people.
Dr. Ambedkar, in his speech of 3rd of November 1949,
Yes,
elaborately discusses about how our federalism works and how it is
Yes.
distinct from the American system.
Correct, my lord. And that is very important. If your lordship, the speech has been shown. The essence of that speech was
What he says that except the situations of emergency, the states would work within the fields assigned to them, and the union would work within the spheres allotted to them. And only when there is an internal or external emergency, the powers shall stand vested all the powers shall stand vested with the central government, so that the country is united and strong at the times of peace as well as war. That is the words he uses.
My lord, that is in a completely, may I, my lord, explain? Unfortunately, in some of the cases also, the understanding of 200 and 201 has become competence-centric.
Has become?
Legislative competence-centric. Where Dr. Ambedkar also said, it's only in emergency that list 2 powers become available to Parliament. Otherwise, the states have their own sphere and must function on their own. Well, let's start by propositions which cannot be doubted. The state legislatures are what the Constitution calls them, legislatures who have the right to make laws. Having conferred this right to make laws, in our federation, we have 2 parallel models, the union legislature and the state legislature. And, my lord, where the Constitution treats the 2 differently, we cannot ever say or remove that difference by reading down or reading up any provisions relating to either of the 2 organs. Your lordship has seen the structure. Article 74, your lordship has Article 74, for example, and see the difference in language and the difference of how the framers of the Constitution made it. 74, and there are 2 dimensions to 74, my lord, and since I'm showing the provision, let me make that point also. There shall be a council of ministers with a prime minister at the head to aid and advise the president, who shall, please, your lordship knows these words, who shall in the exercise of his functions act in accordance with law, with such advice. And here it says, provided the president may require the council to reconsider such advice, either generally or otherwise, the president shall act in accordance with the advice tendered after such reconsideration. Mark this, my lord, with the contrast to the proviso to 201. Then, my lord, we have the legislative procedure in part 5, which begins from Article 107, and this culminates in 111. And I don't need to labor the point that the assent is the last step in the legislative procedure. And 111 says, where a bill has been presented by the Houses of Parliament, it shall be presented to the President, and the President shall declare that he assents or that he withholds assent therefrom. There is no, my lord, any further question of referring the bill to anybody or seeking your lordship's opinion or anything of the sort. Nothing. provided that the President may, as soon as possible after the presentation of the bill for assent, return the bill if it is not a money bill with a message requesting that they will reconsider the bill or any specified provision and in particular any desirability of introducing any such amendments as he may recommend. And when a bill is so returned, the Houses shall reconsider the bill accordingly. And if the bill is passed by the Houses with or without amendment and presented to the President for assent, the President shall not withhold assent therefrom. This article would have had very different connotations if 74 had not been on the statute book. Because all these functions are to be exercised on the aid and advice of the cabinet. But the cabinet cannot alter the bill. If the president in a dialogue with the union cabinet feels that the bill needs to be corrected, he can request and the executive government, the union cabinet takes it back to the parliament. The parliament may or may not reenact it, but what comes out of parliament then is the last word. So this is perfectly consistent. The difference here is the president, even while doing so, is acting on the aid and advice of the union cabinet because 74 is untrammeled. And we do not have any discretionary functions of the president, but that's settled. So, Malad, this distinction, the Constitution has marked in para 1.2, the point therefore which I want to make is marked difference in the scheme in relation to legislative provisions relating to the union and the role of the president vis-a-vis the union government. As against the legislative provision, this distinction is a characteristic of federalism in India. So this is how our federalism is defined in our Constitution. The approach which is based on testing and interpretation of the plain language on the premise that one or the other would be consistent with the principles amounts to defining Indian federalism in abstract terms and then testing the interpretation of provisions on whether the interpretation furthers or distracts from the abstract notion of federalism. This approach overlooks that the founding fathers carefully crafted the provisions and defined the roles of the two legislative bodies in the provisions of the language, which language does not admit of any ambiguity. Reading down any such language on the premise that the consequence would be incompatible with federalism overlooks that the plain language has to be read to define federalism as understood in the Constitution. So, but when we say this is not consistent with federalism, where the language is compelling, you don't stand outside the Constitution to define federalism and then say this construction creates disharmony. By itself, there is no disharmony between two provisions. No disharmony. And one of the points which I will address as I go along is the 254(2) versus 200. It is indisputable that the states have their own identity, but not sovereignty. And where the language of the provision of the Constitution is broad and undefined, an interpretation consistent with broad ideas of federalism may be applicable. But to read down the express language of a provision on the ground that it is incompatible with federalism suffers from the fallacy of circumlocution. Because one of these provisions define federalism. What is our federalism is what these provisions provide. The second principle, Malad.
Salve.
Yes.
The issue is not so much about whether we can use the expression veto or withholding. Occurring by virtue of Article 201 proviso by the end of it. By the interplay of 200 and 201, eventually when a president, by virtue of Article 201 says the bill shall be presented again to the president and the buck stops there. We are not so much on that issue. We are much more on Article 201 substantive portion read with the proviso which the union says can't be done and the substantive provision stands on its own. thereby the power of withholding stands on its own and the governor can withhold a bill.
Manoj, the problem
Let
found.
me
I'm so
just
sorry. I'm
complete
so
it.
sorry. I'm so sorry.
So therefore, when you independently exercise the power of withholding, then this gives rise to a fourth option or the adjunct to the second option, that in the event the bill is sent back with a message by the governor, then the assembly will consider and then send it back. That aspect has a little problematic because at the threshold, the governor, not the president, at the threshold, the governor withholds the bill. Even textually, there is a problem because if that's the power, even a money bill he can withhold. The question of proviso won't apply then. There's a big problem in that interpretation. Assuming for a minute, it is permissible to read the substantive provision along with the proviso, and inevitably the governor sends it back in the event he thinks that it needs to be withheld, then it comes back to him. At the second stage, perhaps the governor will be able to send it to the president, which of course Tamil Nadu says it can't be done. And when
Yes.
it goes back to the president, it is only then that under 201 proviso, the process will come to an end. Till that point of time, the legislative process commences with the assembly, goes to the governor, comes back from the governor to the assembly, and then again goes back to the governor. At that time, he will make an option of either accepting by virtue of the first proviso or sending back to the president. Only then it stops. If you don't construct it in that manner, what will happen is, even at the threshold, a bill can be withheld, or as you say, the process of veto will occur. That's the doubt. How do you construct?
Yes, Manoj. May I answer that straight away? May I answer that straight away? I have a full dress reply, but to my immediate response is as follows. The difficulty which your lordship is pleased to put to me, which has been felt, arises because of the perceived consequences of reading in such a power. Not because of the language of 300, 200. 200 language is plain. But the argument is that means that he can.
To us, how do you understand the proviso which says that except in case of a money bill? So then that's not occurring in the substantive provision.
Correct.
If your construction is accepted, then a money bill can be withheld straight away. Then the proviso
Yes.
won't apply.
Yes.
So he can stop a money bill straight away. At the
Yes, my lord, he
threshold.
can. Yes, he can.
Then read it with the proviso now.
Yes, my lord, that's what I'm saying. If we, for a minute, please look at it a completely different way. Let's put the proviso to one side first.
Please explain, sir.
Yes. My lord, look at it in the reverse.
Yes, Mr. Salve.
Yes. My lord, please look at it in the reverse. Without any preconceived notions, I pick up the book and I start reading 200. Where a bill has been passed by the legislative assembly of a state or of the state having a council having been passed, it shall be presented to the governor, and the governor shall declare either he holds assent or that he withholds assent therefrom, or that he reserves the bill for consideration of the president. But this is untrammeled by any such limitation. If the framers of the constitution knew that there is a separate class of legislation called the money bill and made detailed provisions for money bills, All that they had to do is shall either assents to the bill, or in case of bills other than a money bill, says he withholds assent. Simple. That is how what I would have expected to find if 200 was not to apply to money bills. What we are doing is we are not picking up words from outside the provision and adding it to the provision because we feel that there should be some limitation. Now look at the proviso. Provided that the governor may, as soon as possible after the presentation to him of a bill for assent, return the bill if it is not a money bill, which means one of his three options is limited. What are the three options the governor has? Well, I've tried to formulate it in para 1.5 and 1.6 of my note. The governor is under a duty to make a declaration when a bill reaches him. But I'm not getting into the timelines. I think enough has been said. The governor has a duty to make a declaration. The plain language says the governor shall declare. So he has to make a declaration. So the three declarations are, Malad, I've tried to paraphrase them in 1.6.1, declaring that he assents to the bill, declaring that he withholds assent therefrom, declaring that he reserves the bill for consideration of the president. He then has a fourth option. He returns the bill together with a message to the assembly. Now the fourth option is being used to emasculate the first option. That is, in my humble submission, a complete, unless you start with the premise that, oh, it could not have been ever intended that the governor will have this power. So let's search for some kind of limitation, some implied limitation. If we read the plain language, it's very clear. And these are not high constitutional functionaries acting in enacting legislation. There are so many pointers in the language of 200, which if carefully read will show this entire exercise, Malad, would not really.
Have you used ChatGPT? If your answer is yes, let me tell you something. Around 88% people are not able to leverage ChatGPT to its fullest extent. So the best thing you can do right now is learn how you can leverage ChatGPT to its fullest extent by giving killer prompts. Hi, my name is Aditya Kachwe. I am a graduate of IIT Kharagpur and co-founder of multiple 8-figure companies like Mad About Sport, Beat, NX and Huni. In my 2 hours workshop, I am going to teach you how you can leverage ChatGPT by giving killer prompts, and also I am going to teach you multiple AI tools which will make you 10x more efficient. Not only this, we are also going to discuss, is AI going to take your job, and if yes, then how you can save it. And all these things I am going to cover in 2 hours only at price point of ₹9. And if you register before tonight, I have also included bonuses worth 10,500 rupees. So it is a no-brainer to join this workshop. So see.
Return the bill for which assent is withheld. Well, it would have been as simple as that. There would have been a question of may. Where is the question of saying provided the governor may as soon as possible? And in a same proviso which uses at the end the word shall. So we can't even say, my lord, that it is high constitutional functionaries. So the lawmaker used the word may, and may really means shall. Because for the same constitutional functionary in the same proviso, it uses two expressions, may and shall.
That may is used in the context of two other options that the governor has when he is referring.
Correct.
He will send it back for reconsideration of the bill of any provisions, and in particular will consider the desirability of introducing any such amendments as he may recommend. In
I'm sorry, my lord. The moment we say this is an option, we have displaced the premise that this has to be read into the main part. This is then a separate option. And it is may. It is not that if he withholds assent, he shall send. We have to rewrite these provisions, Manoj, to come to the conclusion that this power to withhold is limited only to cases of sending back.
But how do you reconcile this issue about the bill? That's my last question to you. How do
Yes,
you
Manoj.
reconcile? How do you reconcile that a money bill can be rejected at the outset by the
Yes, it
governor,
can.
by the substantive provision, and
Yes.
then the later portion says, then again he has the option. He
Correct.
says that return the bill if it is not a money bill.
So, Manoj, as far as
He can only withdraw he can only withhold at the outset. Money bill
Manoj,
he can
please.
withhold only at the
Yes.
outset. I'm having
Yes,
a
Manoj.
problem about
That's
reconciling the proviso with money bills.
yes, Manoj, it's not a question of reconciling. It is asking the question, with great respect, asking the question, why did they make it for other than money bills? The answer is very simple. Grant of assent.
Mr. Salve, only if you can give me a minute.
Yes.
Absolutely.
207 is the answer, my lords, to my Lord Justice Nasima's question. Special provisions as to financial bills. My Lord, 199 is, my Lord, financial bills, which is
Money bill, money bill.
Yes.
207 we have.
Yes, my lord. A bill or amendment making provision for any of the matters specified in subclause A to F of clause 1 of article 199 shall not be introduced or moved except on the recommendation of the governor. And so he cannot, there is no question of withholding.
Therefore, then your argument that he can withhold under the substantive provision goes. In the substantive provision, your whole argument is that it is open-ended and it can be withheld by the governor.
No. There is no occasion for withholding a money bill because the introduction itself is with the recommendation of the governor.
So therefore, in a money bill, there is no withholding.
Yes, my lord. Yes. Your lordships are right.
The presentation is with recommendation.
Yes, your lordships are.
207 requires the consent of the governor. What he's saying.
My apologies.
May I, my lord, point out, there may be a third situation.
Yes, consideration.
I was going to deal with 207, my lord, but there may be a third situation. I just want to test it. A money bill is introduced with the recommendation of the governor. The bill may undergo changes on the floor of the House. It doesn't say that the money bill is introduced has to be passed. If what is approved finally doesn't accord with what was recommended by the governor may withhold assent. The point is, my lord, important that the framers of the Constitution created a separate safeguard. In 207, and perhaps did not consider it necessary in the light of that to extend the fourth option to money bills. I wonder if my point is clarified. I am not saying that the assent to a money bill cannot be withheld on its plain language. But it will be extremely odd, and therefore all argument of abuse, which should never be brought in, to say that having recommended a bill, the governor will then withhold the bill. But where the power should be exercised, how the power should be exercised, and the existence of power are two very different questions. What your lordship's question is, and I assume that's what I'm addressing, the existence of power, not how it will be exercised.
So we are not on the question of abuse at all. We are on constitutional interpretation.
Exactly, existence of power. That's right. So, my lord, existence of power to withhold.
While deciding this matter, we will not be looking at the Tamil Nadu fact.
No, but my lord, I see that. I see the wisdom of that, my lord, because the old story of hard facts, bad law, my lord, should not visit any such matter of such a moment. Article 200, my lord, in the fourth option of sending back removes money bill because that has already been done. If despite that, if the money bill as recommended is accepted, I'm answering my lord Justice Narasimha's question. If the money bill as extended is what is passed as recommended by the governor, in theory he may have power to withhold, but the question of exercising that power would not really arise. But if the money bill as recommended by the governor is not accepted, because nothing prevents my lord on the house to make floor of the house to make changes to the money bill. A bill which finally comes for assent may not accord with what was recommended. The governor may withhold consent. Now, if the fourth proviso did not accommodate money bills being sent back, it was because if your recommendation has already been there, if that recommendation has been disregarded, there is no question of sending it back. Then you decide you either grant assent or don't grant assent. The proviso was meant in recognition of a very important principle in a democracy, the principle of consensus. That if the governor sends the message and it goes to the assembly, he is then trusting it to the wisdom of the assembly. The wisdom will act with responsibility, will consider the governor's message, and then will pass it. And in which case, their word, as far as they are concerned, the governor then doesn't have the power to withhold assent. Now, the argument against this construction that do not construe this so widely as recognizing this power is because you are creating a veto. My lord, this word veto doesn't fit in constitutional debate. What we are saying is you are creating a power, or you are interpreting the provision to show that the power of this high constitutional functionary may extend to stymieing a bill and prevent it from becoming law. Well, I submit that is quite consistent with the scheme of the Constitution when you read 201. So if the governor sends it back and it comes back to the governor, then his 2 out of 4 options are ruled out. He then can either grant assent or he reserves the bill for President's consideration. Withholding assent is ruled out and he has already gone through the assembly. He can't send it back a second time. In other words, the controversy then moves between the union and the state. The judgments have been shown, and that's why I'm not citing any of those cases, that the governor ultimately is the points person, is the nodal agency for harmony between the union and the states. So he is the first stop. And my lord, it will be in real constitutional sense, it will be hard to believe that a governor will really act on his own, where there is a strong push from the assembly to pass a law. He may well, to start with, refer it to the president. Or he may try working with the assembly, and if it doesn't work, he may refer it to the president. But the basic notion that once a law is made by the assembly, then an assent must follow is wrong. If it is not a feature of Indian constitutional federalism that an assent must follow after 1 or 2 rounds or 3 rounds of confabulations, and the assembly must have the same power to have the last word as parliament does. If that is not the scheme of the Indian constitution, then my lord, we have to go back to the drawing board and define what is our federalism. And it is a limited federalism. In the hope that all framers, that all these high dignitaries who have been conferred with this power will act with wisdom, will act to protect the constitution, and will act to further the values of democracy, because these are the assumptions we have to make. This is how it was done, with a final check or safeguard saying, in rare cases, the moment a law made under the heat of the moment in a state may not be allowed to become law. The political process will resolve the political crisis which may follow. But that's not then in the realm of constitutional law. This, my lord, is the absolute plain meaning of the compelling language, unless we start rewriting express provisions such as 200, 201, 254(2), etc., etc. So, my lord, I close this point saying,
Mr. Salve,
yes,
111.
yes.
If a president withholds without application of the proviso, here also there is an expression may in the proviso.
My lord, 74(2) will come into play. He can be advised to present. The president has no discretion. He has to act on the aid and advice of power. So the manner in which this power will be exercised becomes qualitatively different.
How does it?
Yes, ma'am. Please see 74(2).
The question whether any, and if so, what advice was tendered by the minister?
No, I'm sorry, 74(1). I misspoke. 74(1).
One proviso, you mean?
No, the main one is that the head to aid a president in exercise of his functions, and this is untrammeled. all his functions, act in accordance with such advice. So if he is advised, if in discussion he can have, but in all these, there is an element of political processes recognized. So the president may call the union government and say, I have these doubts. Do you mind taking it to the parliament? They may say, yes, we take it to the parliament. Or if he advises no, that please give assent, he has to give assent. Because 74-1 is the marked difference. And your lordship has been shown all the cases. The difference between the governor and the president.
That's there.
So, this is why I submit. Now, my lord, apply 74-1 to 201 proviso. And that is the scheme of Indian federalism. When it is presented to the president for his consideration, it means, and the president will obviously act on the aid and advice of the union government.
Possibly didn't know your lordships are conferring. Mr. Salve didn't know that your lordships are conferring.
I'm so sorry. I'm so sorry.
Withholding assent in the countries by Day-5.
So according to those, the president is bound by the aid and advice of the Council of Ministers in the Union. The same is not insofar as states is concerned, and the governor has his own discretion.
That's clearly the position.
Yes.
That's a sharp difference between the two. And in the same constitution, my lord, when we have two structures, it was for the founding fathers to have decided. They could have created a similar structure for the states, but they did not.
Yes.
Now, my lord, textually, I have therefore concluding my submissions in para 1.7. The proviso uses two expressions, may and shall. The founding fathers would have and could have provided that the governor, upon withholding assent, shall refer the bill to the assembly if the intent was to limit the power of withholding only for the purposes of sending the bill with a message. The second proviso, now this is another interpretational aid. The second proviso is mandatory in nature, leaves no discretion to the government. So, when they wanted to make it shall, they have made it shall. So, these are very carefully crafted provisions. The general principle that in certain cases may must mean shall, because when you are referring to high constitutional functionaries, you would use the word may even when you are casting a duty, cannot apply to these provisions because when they want to, they use the word shall. And therefore, my lord, on textual interpretation, the scheme of 200 leaves no manner of doubt that the founding fathers did not intend to make the referral of a bill to the House with a message a necessary consequence of withholding assent. The obvious reason for not doing so was whether governor withholds assent in circumstances where there is a sharp political division, and in the opinion, the bill should not be allowed to become law. There may be cases like this. Needless to add, this is a far-reaching power. And if it is likened to a veto, it only means that the founding fathers wanted to reserve a veto. The fact that such a veto does not detract from the federal character of that there is such a veto does not detract from the federal character as defined in the Constitution. This is our federal character. We must not first see these provisions and say whether India has a federal constitution or not, and to what extent. It's not the other way around that we start with that India has a federal constitution. Now let's start chipping and recasting provisions which don't fit
Yes.
Now, at para 1.9, I close this point. It is obvious that the power of withholding assent is to be exercised by the governor in larger public interest with wisdom and for the purpose of preserving and protecting the constitution. To assume that the government would be oblivious to the quasi-federal character of the constitution is to assume that the governor would abuse the power, which is not a permissible principle of India. May I continue, Madam?
Yes.
May I continue? Yes. Now, on a slightly different but connected point in 110, Article 200 does not set out a time limit in which the governor has to exercise his discretion in issue of one of the three declarations or exercise the power under the proviso. The obvious reason is that the governor has to take a considered decision on the future course of action in a manner which would be consistent with the constitutional balance between the institutions while maintaining due deference to the wisdom of the legislature of the state. It cannot be assumed that in every case where the governor has not issued the declaration immediately or in a short period of time, the governor is guilty of inactivity. But political processes take place, behind the scene discussions take place, negotiations take place, consensus building takes place. It may be achieved in 15 days, and one case may take 4 months in the other case. We cannot have timelines because a lot goes on before one or the other decision is taken, and it should go on. This can't be sitting in an ivory tower and making decisions. The real politics takes over. The consensus building is required. That's all that I have to say on the timeline. Other points have already been made. The proviso to 201, unlike the proviso to 200, makes it clear it is for the president to be satisfied that the bill has been duly reconsidered. If the president is not satisfied that the bill is passed, the president may withhold assent. It is not suggesting that the president is duty bound to act in the same way as the governor, where the governor exercises discretion to refer the bill to the legislative assembly. I have already made that point. The fallacy in arguing that there is a veto, which would come about if the first proviso is not read into the power of the governor to withhold assent, is apparent from when the language of the proviso to 201 is taken into account. If the president refuses to assent, it would by the same token be characterized as a veto by the president. Reading 200 and 201 makes it clear that unlike Union Parliament, the powers of the state legislatures are subject to the assent of legislation in the ultimate analysis by the President of India. I pause here, my lord. There is a reason why I put it like this. My lord, the governor is appointed